a very difficult task of weeding out some of these regulations. I think you're working with a scalpel. If you're not successful pretty soon, I think we're going to come in after you with a machete, because I think it's something that needs to be taken care of. I want to start off by addressing something of particular interest to the state of Texas, and that's specifically the cross-state air pollution rule. And this is a symptom that we're seeing on multiple occasions in Texas. We saw it with the dune sagebrush lizard, where Texas is not originally included in the original proposals and not given an opportunity to take part in the rulemaking process. And then as the final rule comes out or is about to come out, all of a sudden we are thrown in there. And it was about a month ago, I think almost the entire Texas delegation sent you a letter with respect to these cross-state air pollution rules. Have you had a chance to read that letter and follow up on your offer, maybe to help us out on that?
Well, yes, definitely. That letter followed a discussion I had with almost the entire Texas delegation, both Democrats and Republicans. And subsequent to that, receiving that letter, I've transmitted it to the Environmental Protection Agency, which I can assure you is thinking intensely about the issues that were raised.
All right, let's just step back now and look at a broader perspective. You're seeing now agencies more and more going into these emergency rulemaking procedures where the rules take effect immediately and end up being in effect permanently. Do you think we've maybe broadened the definition of what an emergency is beyond what the average American citizen would think is an emergency?
You're taking me back to my days as an administrative law teacher. The Administrative Procedure Act allows agencies to dispense with notice and comment rulemaking when it's unnecessary, impracticable, or contrary to the public interest. That's the statutory term. Sometimes that's referred in shorthand as an emergency exception, which I think is a useful way of reminding everyone, maybe particularly agencies, that the ordinary course is to go through notice and comment. What I believe and what OIRA is firmly committed to, and what the President, more importantly, has directed us as of January 18th to be firmly committed to, is a 60-day notice and comment period, unless there's some very unusual circumstance.
And can you talk a little bit about sue and settle, where agencies are basically forced to implement rules as a result of a lawsuit from an activist group and basically sidestepping the normal procedure that way as well?
Well, I think there are a couple of different situations that rubric might capture. Let's describe the optimistic one first. The optimistic one is where the plaintiff, it could be a company that wants to avoid a burden, it could be an environmental group that wants to clean the air or the water, has a really good argument on the merits, let's suppose. And then the agency decides we're going to lose. Why don't we enter into a settlement agreement which will give us, in some cases, more flexibility and room to maneuver than could happen if the case went to trial. So that is completely legitimate. All I would say as OIRA administrator for that one is that it should be clear that the public comment process and the legal requirements of the statute and the requirements of the executive order, including careful cost-benefit analysis, choice of least burdensome alternative, et cetera, to the extent permitted by law, all have their appropriate play.
I would love to sit down with you over coffee and have about 30 minutes to discuss that and the separation of powers issues associated with it on a former lawyer to law professor level. But I've only got about 30 seconds left, so I want to just pose one more thought for your consumption as well as those that are watching. Historically, we've had scientists that are running these government agencies and in leadership posts. And I think now more than ever we're seeing political appointees, and very often political appointees from activist organizations that are taking over leadership roles in executive branch regulatory agencies. Do you see that as a trend and or as a problem?
Okay, it's a great question, and I don't have enough kind of data about what the trends have been. I would say is very clear after my 2.5 years at this office is that scientific issues are often fundamental to regulatory decisions, and I agree with you. The scientific decisions have to be made by scientists, not by people who are political.
Thank you very much. I see I'm out of time.
That's a rare sight you have. Okay, well, I guess I will recognize myself for